Welcome back to the PI show, everybody. It's now time for my favourite section in the show, the mailbag section.
Why wouldn't it be? It's your segment.
That's right, it's the only segment I'm on, so it's my favourite. Now, I've had lots of interest on the website this week, the pishow.com. A lot of questions coming through, and I've got some interesting ones today. So the first question is from Danny in Carlton. Dear Harry and Tony, I work in an office and I have a really bad back. In my last job, I made a request for an ergonomic chair to be ordered, but this was never done. I was also told to carry heavy boxes, even though my manager knew that I had a bad back. The pain in my back got worse, and when I asked for a better chair, I was fired on the spot. I now take anxiety medication because of the treatment I received at work, and I'm also on strong pain medication for my back. I haven't worked since. Do I have a work cover or a negligence claim against my former employer? Thanks for that, Danny. And what do you guys think about this question?
Danny, you should come in and get legal advice, but the preliminary thoughts are that there is a work cover claim for weekly payments of compensation. It sounds to me as though the back has been aggravated by your last employer. So if that's the case, the first thing you've got to do is fill in a claim form and put in a claim. The work cover authority's got 28 days in which to accept or reject that claim. But prima facie, you've got entitlements to weekly payments and medical and like expenses. Then you'd have to consider whether there's entitlement to what's called no-fault benefits for a permanent injury to your back. And that is after 12 months you can lodge a claim. And finally, there may be a claim for serious injury if the aggravation itself, that is the back that's been made worse by your last employer, is serious. And again, if you're unable to work, prima facie it's serious.
The only thing I'd add to it, Harry, is the fact that these facts do sort of support a claim in negligence. That is on the fault question. So I agree with you, what you've said, that the only thing you really got to determine is, is the injury serious? Because don't forget he was fired. He didn't leave of his own.
Danny, it's female.
Sorry.
She was
Danny
fired.
didn't leave of her own volition. She was fired. So you got to look at capacity for work and things like that. So I'd imagine, look, but I agree with Harry. It's looking like a serious aggravation.
Yeah, but it sounds like her back injury wasn't injured at her last employer, could have been injured a while before that. However, if it's been made worse, and that's probably a matter of medical evidence,
yes.
If it's been made worse, then you've got to look at the last employer being liable for both statutory benefits and for common law. I agree with Tony. And finally, may I say, they might be superannuation benefits that the person might have access to in addition.
That's right.
Oh, okay.
So there's all sorts of issues, and you're prudent to consult a lawyer, and then they can advise you about
and
your
collate
rights.
the evidence and take it from there.
Yeah.
Evidence is important as well.
Now, Harry, you mentioned that she was entitled to weekly payments and medical and like expenses. Is it right that she doesn't have to show negligence of the employer, that she has that right anyway?
She's got a right no matter whose fault it was, and they're sort of ongoing benefits till 65. So they're no fault benefits in Victoria.
Well, good luck, Danny, and take care of yourself.
And get advice.
All right, the next question comes from Damien in Brunswick. To the PI show. On a recent bus trip, my grandma fell over when the bus moved before she sat down. She couldn't move after she fell, and I had to call an ambulance. She broke her arm, her leg, as well as a few ribs. She hasn't been able to walk since. Does she have a claim against the bus company or a TAC claim? Well, what do you think about this, Tony?
Well, I think she's got a claim pursuant to the Transport Accident Act for no fault benefits because she's on a bus and it's moving. It's been in the driving of a vehicle, so I'm pretty sure that it's pretty much covered. The other thing about common law damages, if she's got a serious injury, and she might have, because she's got broken arm, leg and other things, I would have thought the bus driver taking off before she's sitting down gives you some hope.
Yeah,
it's arguable.
do you think that's negligent?
Yeah, look, I've seen plenty of these cases, And I've seen the other cases where people are trying to get off the bus or a tram and they take off before the people have gotten off the tram.
Okay.
So, yeah, look, it's sort of arguable. You need to know more, but it gives you something to look at. Yeah. I think...
I agree with you. It's a TAC claim. The TAC is an insurer that steps into the shoes of the bus company. So you're suing the bus company, but TAC are the insurer of the bus company because it's a registered motor vehicle. And then it's got no-fault benefits. That is, for all the medical expenses and treatment would be covered. Maybe household help would be covered. And then you'd have to look carefully, as Tony says, about negligence because you want to know how many people were on the bus, what circumstances the bus sort of took off before everyone was seated, whether the driver had looked in the rear vision mirror and checked whether everyone had been seated or not. So,
and it depends on his driving. Could have been erratic. You know, he might have been very, very too quick to take off. Quick off the mark, you never know.
Does it make a difference that she was a grandma, so she might have been very old?
Well, a bus driver's got to be appraised. He's got to look over and see who's on the bus. He just can't assume that everyone's
I think that's a good
nimble.
point because you've got to take into account people's age and experience and you know how they've gotten on the bus, where they're sitting, and their age is, I think, an important consideration. I think it's a good point.
All right. Well, thanks for that question. Our last question of the day is from Callum in Armidale. Supermarkets are now putting up signs that people should watch out for grapes on the floor as they have realised that people can slip on them. Does this protect the supermarket from liability? What if they don't clean the floor for a couple of days and that was the reason the grapes were on the floor? I don't think putting up a watch for grapes sign is enough. Thanks, Callum.
I agree. I don't think putting up a sign is enough because if the facts are that they haven't cleaned for a couple of days, one of the key issues in these sorts of cases is what cleaning system have they got? And 2 days in a very busy supermarket is too much. And even though you've got a sign, watch out for grapes, they're small, you can't see them, so they could be anywhere. And they're almost like a hidden trap or risk.
But do you think the sign does anything to...
It puts you on notice, but you can't go looking for these little things, you know, they're small. Grapes are small.
Yeah.
So that last little bit about not cleaning the shop for 2 days is pretty significant in my eyes. And the show's rolled on very fast, guys.
It has.
And,
keep sending us your questions. We love to read and also answer your questions.
So that's
Just go to thepishow.com and we'll see you next week.
And Harry, before we go, I think Dr. Larkins is on next week. Peter Larkins should be interesting.
Well, we've got a show dealing with sports injuries, and I think there will be a special guest who is an expert in sports injuries.
Yeah, that should be great.
So it'll be a good show.
Thanks, Harry. Beth, thank you, viewers.
Thanks for watching.
And stay tuned for next week.